I commend the Judiciary for the admirable work that it has done in discharging its onerous mandate of enforcing the Bill of Rights. Time and again, as expected by the framers, the elastic limits of our Constitution have been tested. Invariably, the Judiciary has risen to the occasion over the last 14 years and guided the nation on the constitutional way forward without fail. The Judiciary has stood as a bulwark against any threats to the rights enshrined in the Constitution. During the 3 changes in its leadership, it has guided us on key jurisprudential questions, including those touching on legislation by Parliament. In particular, the Supreme Court has recently guided on the parameters that a court should consider before declaring a statute to be unconstitutional. Honorable judges, in our work as Parliament, we have been keen to ensure the discharge of our legislative representation and oversight roles upholds fundamental rights and freedoms to the fullest extent. Through tools such as questions, petitions, and statements, legislators have raised issues in the House on cases of violations of human rights for action and sought responses from the executive and relevant bodies. Additionally, Parliament has enacted laws that implement human rights. Notably, the National Assembly is presently considering the Persons with Disabilities Bill 2023, which seeks to implement the rights of persons with disabilities as enshrined in Article 54 of the Constitution. With respect to oversight, Parliament and its committees have conducted various inquiries and investigations on violations of human rights and commended the appropriate action and remedies to these grievances. Presently, committees of the National Assembly are engaged in inquiries relating to alleged human rights violations by the British Army Training Unit in Kenya and the alleged historical and systemic dumping of toxic waste in the northern parts of the country. The Judiciary has stood as a bulwark against any threats to the rights enshrined in the Constitution. During the 3 changes in its leadership, it has guided us on key jurisprudential questions, including those touching on legislation by Parliament. In particular, the Supreme Court has recently guided on the parameters that a court should consider before declaring a statute to be unconstitutional. This is one area where Judge Ogola and your team, I want to urge you to give the public some degree of consistency and also to now adhere to what the Supreme Court has said, which is a principle espoused all over in comparable jurisdictions, that when a bill is passed by Parliament, there is a presumption of constitutionality of that bill. And anybody who comes to court to challenge it, and as they should, because Kenyans have the right to come to court and challenge the constitutionality of any bill. The moment such a matter is brought before you, in my view, and in view of now the Supreme Court, it automatically raises tribal issues. And it is good to hear both parties before you make a declaration.